On May 1927, the Supreme Court of the United States delivered its opinion in the case of Buck v. Bell. The case concerned a 21-year-old woman named Carrie Buck. She had been committed to the Virginia State Colony for epileptics and feeble-minded. The state wanted to sterilize her without her consent. She did not want to be sterilized. The question before the Supreme Court was whether the United States Constitution permitted the government to forcibly remove a woman's ability to have children because the government had decided she was genetically unfit to reproduce. 8 justices said yes. 1 said nothing. Justice Pierce Butler, the lone dissenter, wrote no opinion. He simply voted no and remained silent, which in retrospect looks less like reticence than like a man who understood that articulating his objections would require engaging with premises. He found too ugly to dignify with argument. The majority opinion was written by Oliver Wendell Holmes, Jr., at that moment considered by many legal scholars to be the greatest judicial mind in the history of the American bench. He was a decorated Civil War veteran, a Harvard-educated legal philosopher, a man whose writing on free speech and the nature of law had shaped constitutional jurisprudence for 3 decades. He was, by any measure, one of the most distinguished figures ever to sit on the Supreme Court. His opinion in Buck v. Bell was 3 pages long. In those 3 pages, Holmes reviewed the facts of the case, which were, as we will see, substantially fabricated, and concluded that the Commonwealth of Virginia had the right to sterilize Carrie Buck against her will. He drew an analogy to compulsory vaccination. If the state could require you to accept a needle, it could require you to accept a surgeon's knife. He argued that if the public welfare could demand the lives of its finest citizens in wartime, it could surely demand this lesser sacrifice from those who were, in his assessment, a burden on the state. And he closed with the sentence that has been quoted in law school classrooms, academic papers, and history books ever since, quoted not as an example of legal brilliance, but as an example of what happens when an institution with enormous power and enormous prestige uses that power and prestige to endorse something that is beneath its formal authority. Simply wrong. It is better for all the world if, instead of waiting to execute degenerate offspring for crime, or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. 3 generations of imbeciles are enough. 3 generations of imbeciles are enough. The opinion was widely praised. The Charlottesville Daily Progress, reviewing it, called it a genuine classic and praised its progressive tendencies. Time magazine, reporting on the decision, described opponents of the ruling as sentimentalists. 7 states and Puerto Rico enacted new sterilization statutes within the decade, modeling their laws on Virginia's now court-tested one. In the 10 years following the Buck v. Bell decision, almost 28,000 Americans were sterilized under eugenic laws. In the years and decades that followed, the total exceeded 60. 60,000 Americans forcibly sterilized under laws that the Supreme Court had just declared constitutional, under a scientific theory that the scientific community would, within the decade, begin to recognize as fundamentally and catastrophically wrong. There are 2 things you need to know about Carrie Buck before we go any further. The first is that she was not, by any reasonable measure, feeble-minded, the clinical category on which her sterilization was predicated. She had been taken out of school in the 6th grade and put to work as a housemaid in the home of her foster family. She had been raped at 17 by her foster family's nephew. When her pregnancy became visible, her foster family, the same family whose nephew had raped her, had her committed to the Virginia colony for epileptics and feeble-minded, on the grounds that she was mentally deficient and sexually delinquent. Her newborn daughter was removed from her care. Her lawyer at the Supreme Court was a man named Irving Whitehead. Whitehead had been appointed as her guardian. He presented, by any analysis of the court record, one of the least vigorous legal defenses in the history of capital litigation, and this case, while not a criminal proceeding, was one in which the state was seeking to permanently alter another person's body without her consent. Whitehead called no scientific witnesses to challenge the eugenic theory underlying the sterilization law. He made no sustained argument that the evidence about Carrie Buck's alleged hereditary deficiency was fraudulent. He did almost nothing, in practice, to defend her. This was not incompetence. Whitehead was himself a eugenic supporter. He had previously served on the board of the very institution that was seeking to sterilize Carrie Buck. The case had been, from the beginning, a staged legal proceeding designed to give the eugenics movement a Supreme Court blessing with Carrie Buck as the unwilling protagonist of a test case whose outcome had been, to a very significant degree, arranged in advance. The second thing you need to know about Carrie Buck is that her daughter Vivian, the infant who had been described in court as not normal and listless, whose supposed feeble-mindedness was used to establish the third generation of imbeciles that Holmes found so dispositive, was, by all later accounts, a perfectly ordinary child. She attended school in Charlottesville. She was remembered by her first-grade teacher as bright, inquisitive, and a good student. She died at the age of 8 from an intestinal disease. She was never tested for intellectual disability with any instrument that a modern psychologist would recognize as valid. She was called feeble-minded because a eugenics expert, in a brief deposition, said so about a child he had examined when she was an infant. For a few minutes, based on criteria that had no scientific validity, Oliver Wendell Holmes built the most famous phrase in the history of American eugenics on a foundation of 3 fabrications: a woman who was not feeble-minded, a lawyer who was not defending her, and an infant whose deficiency had been invented for the occasion. The Buck v. Bell decision has never been formally overturned. It is still as of today, technically the law of the land in the United States. Later, Supreme Court rulings have significantly narrowed its application, and modern constitutional doctrine has moved so far from the eugenics framework that any attempt to revive the Buck v. Bell precedent for its original purpose would face formidable legal obstacles, but the decision has never been explicitly reversed. The words "3 generations of imbeciles are enough" remain, technically, binding Supreme Court precedent. The opinion remains on the books, as valid in the formal legal sense as the day it was written. This episode is the story of how a country arrived at that moment. How a theory that most people today would immediately identify as pseudoscience was, for several decades, treated as cutting-edge scientific knowledge funded by major institutions, endorsed by major universities, legislated into law by 32 states, and blessed by the highest court in the country, and how that theory, developed and refined and exported by American scientists, crossed the Atlantic Ocean and helped to provide the intellectual and institutional foundation for a program of racial hygiene that would eventually be prosecuted at Nuremberg as a crime against humanity. The story begins, as these stories so often do, with a man who was very confident he was doing something good. Let's begin with Francis Galton. Galton is, in the history of eugenics, in the starting point, the man who coined the term, who articulated the core idea, and who gave a nascent intellectual movement its scientific vocabulary. He was a Victorian polymath, a geographer, a statistician, a meteorologist, the inventor of the weather map, a contributor to forensic science through his work on fingerprints. He was also, by any measure of intellectual achievement, genuinely brilliant. He was Charles Darwin's half-cousin. He had read on the origin of species and had drawn from it a conclusion that Darwin himself had not drawn and would not have endorsed, that if natural selection could improve species over time, then deliberate human selection could improve the human species in a single generation. He called this idea eugenics from the Greek, meaning well-born. He defined it in 1883 as the science of improving stock, which is by no means confined to questions of judicious mating, but which, especially in the case of man, takes cognizance of all influences that tend in however remote a degree to give to the more suitable races or strains of blood a better chance of prevailing speedily over the less suitable. He presented it not as prejudice, not as the mere preference of one group of people for themselves over others, but as science, the systematic application of biological principles to the improvement of humanity. Progress, measured in bloodlines. The idea had an enormous appeal in the late 19th and early 20th centuries, and understanding that appeal is essential to understanding what followed. The appeal was not primarily to the worst instincts of the people who embraced it. It was to some of their better ones, or at least to instincts they experienced as better ones. The turn of the 20th century was a period of profound anxiety about social change. Industrialization was reshaping Western societies at a pace that felt disorienting. Immigration was changing the demographic character of cities. The populations of institutions, hospitals, prisons, asylums, poorhouses were growing in ways that seemed, to contemporary observers, alarming. The social problems of the industrial age, poverty, crime, alcoholism, mental illness, prostitution were visible, mispressing, and resistant to the reform efforts that earlier generations had believed would solve them. Into this environment, eugenics offered something seductive, a scientific explanation for the persistence of these problems, and a scientific solution. The poor were poor in this framework, not primarily because of economic structures or social arrangements, but because they carried genetic deficiencies that predisposed them to poverty. Criminals were criminal because they inherited criminality. The mentally ill were mentally ill because of hereditary degeneracy. These were not problems that social reform could solve. They were biological problems that required biological solutions. The solution eugenics proposed was the selective management of human reproduction, encouraging the fit to have more children, and preventing the unfit from having any. The language was the language of animal breeding stock improvement. Defective germplasm. Degenerate bloodlines applied without irony or apparent discomfort to human beings. It was the language of farmers and livestock managers, transposed to the management of populations. What made eugenics dangerous was not primarily this core idea in its abstract form. The core idea is wrong substantially, fundamentally, and in ways that modern genetics makes clear, but the harm required a specific institutional infrastructure to become real. The harm required that the idea be taken up by scientists with sufficient credibility to make it look like legitimate science, funded by institutions with sufficient resources to give it operational scale, and endorsed by governments with sufficient power to enact it into law. All three of these things happened in the United States. The institutional center of American eugenics was a facility in Cold Spring Harbor, on Long Island, New York. In 1904, the Carnegie Institution of Washington, one of the most prestigious scientific funding bodies in the country, established the Station for Experimental Evolution at Cold Spring Harbor. In 1910, the Eugenics Record Office was added to the campus, funded initially by Mary Harriman, the widow of railroad magnate E.O. Harriman and one of the wealthiest women in America, and subsequently by the Carnegie Institution itself. The Rockefeller Foundation also contributed. The Kellogg family, yes. The cereal Kellogg's supported eugenic research through their Race Betterment Foundation. These were not fringe donors. These were the premier philanthropic institutions of American science and industry, channeling their resources into an organization whose explicit purpose was to identify genetically unfit Americans and prevent them from reproducing. The director of the Eugenics Record Office was Charles Davenport, a Harvard-trained biologist with a legitimate scientific background, a genuine expertise in Mendelian genetics as it applied to animal breeding, and a vision of eugenics as the logical extension of that expertise to human populations. Davenport was not, in his own self-understanding, a bigot. He was a scientist. He believed he was applying the best available biological knowledge to the most pressing social problems of his age. He was wrong about the science, about the methodology, about the basic intellectual architecture of what he was doing, but he was wrong in the way that serious people can be wrong when they are deeply committed to a framework that flatters their assumptions and serves their social prejudices while wearing the costume of scientific rigor. Davenport's partner in the ERO's most consequential work was Harry H. Laughlin, a man who combined genuine administrative energy with a quality that is, in the history of institutional atrocity, highly characteristic, the quality of ideological commitment so intense that it functions as a substitute for intellectual rigor. Laughlin was not primarily a scientist. He was an operator. His interest in eugenics was specifically in its application to policy, to immigration law, to sterilization law, to the systematic management of the unfit by the machinery of government. The ERO's method was the field survey. Teams of specially trained workers, the ERO, trained 258 field workers between 1,910 and 1,924. Most of them women with degrees in biology fanned out across American institutions, hospitals, asylums, prisons, reformatories, orphanages. They interviewed patients and inmates. They collected family histories. They filled out standardized trait cards, enormous numbers of them. The ERO eventually accumulated millions of index cards on ordinary Americans, systematically cataloged according to their reported physical, mental, and moral characteristics. On the basis of these cards, researchers constructed family pedigrees, tracing the supposed inheritance of traits like feeble-mindedness, criminality, pauperism, and sexual immorality through generations of American families. This methodology had a problem. Actually, it had many problems. But the central one was this. The traits being measured were not the kind of traits that Mendelian genetics, even in its early, imperfect, 1910s form, could support as simple hereditary characteristics. Feeble-mindedness was not a biological category. It was a social category, a catch-all label applied to people who failed various kinds of institutional tests, who behaved in ways that institutional authorities found problematic, who were poor, immigrant, non-English speaking, or simply different from the people doing the classifying. Intelligence. To the extent it is heritable at all, and it is partly heritable, in complex and heavily environment-influenced ways that took decades of subsequent research to begin to understand, does not follow the simple, dominant recessive patterns that Mendel had described in pea plants. Neither does poverty, or criminality, or sexual immorality. These are not discrete biological traits controlled by single genes or simple gene combinations. They are complex outcomes produced by the interaction of genetic, environmental, developmental, economic, social, and cultural factors in ways that make any attempt to trace them through simple pedigree analysis scientifically worthless. The geneticists who knew this said so. Thomas Hunt Morgan, who would win the Nobel Prize in 1933 for his work on chromosomes and gene mapping, pointed out, as early as 1925, that eugenicists were making claims their data could not support. Morgan's objection was not political. It was scientific. The methodology was wrong. The data was invalid, and the conclusions did not follow from the evidence. Herbert Spencer Jennings, a zoologist at Johns Hopkins, made similar arguments. The scientific criticism of eugenics was available to anyone who looked for it. Most of the eugenics movement was not looking for it. The ERO had millions of index cards. It had Carnegie Institution funding. It had an air of scientific seriousness that made the methodological critiques seem like the objections of sentimentalists rather than scientists. And it had, increasingly, the attention of politicians and legislators who were looking for scientific justification for policies they wanted to pursue for reasons that had considerably more to do with race and class anxiety than with genetics. The first American state to pass a eugenic sterilization law was Indiana. In 1907, the law provided for the involuntary sterilization of confirmed criminals, idiots, imbeciles, and rapists in state institutions. By 1914, 12 states had enacted some form of sterilization legislation. By the 1930s, 32 states had such laws on their books, covering a range of unfit categories that varied by state, but almost always included feeble-mindedness, and often included epilepsy, mental illness, sexual perversion, and various other categories of supposed hereditary deficiency. California, which passed its sterilization law in 1909, was the most aggressive enforcer. In its first 25 years of eugenic legislation, California sterilized 782 individuals, mostly women, disproportionately poor, disproportionately immigrant. Many were classified as bad girls, diagnosed as sexually wayward, passionate, oversexed, at the Sonoma State Home. Some women were sterilized on the grounds of what institutional physicians described as abnormal physical characteristics. The specific details are almost too grotesque to cite in a discussion of what was supposed to be a scientific program, but they are documented, and they are real. And they are the direct product of a scientific framework that had convinced itself that poverty and social deviance were biological conditions requiring surgical solutions. Many of the people sterilized under these laws were not told what was being done to them. Carrie Buck's sister Doris, sterilized under the same Virginia law that had been used on Carrie, was told she was having an appendectomy. She spent years wondering why she could not have children, trying to conceive, consulting doctors who could not help her. She did not learn the truth until she was in her 60s. When a researcher named Paul Lombardo, who was piecing together the full history of the Buck 5 Bell case, told her what had actually happened in that operating room decades earlier. This is the specific texture of what the eugenics movement produced in practice, not the abstract policy debates about fitness and heredity. The specific woman, in the specific room, being told she was having an appendectomy, and then going home and spending the next 40 years trying to understand why she couldn't have children. Meanwhile, a scientific pretense was maintained. The ERO published journals. It held conferences. It organized exhibitions. There were, at various American state fairs in the 1920s, Fit of Families contests, an application of the county fair livestock competition format to the assessment of human genetic quality. Families would present themselves for examination by ERO-trained assessors who would evaluate their physical and mental characteristics and award prizes: bronze, silver, or gold to those deemed most genetically meritorious. The winners received ribbons. There were photographs taken. The photographs have the cheerful, sun-drenched quality of all mid-century county fair photography, and they are among the more unsettling images in the history of American science, precisely because of that cheerfulness, the complete comfort, the absence of any visible sense that something is wrong with what is being done here. The ERO, at the height of its influence in the 1920s, was not a fringe institution. It was housed at Cold Spring Harbor, one of the premier biological research facilities in the United States. It was funded by the Carnegie Institution. Its work was cited in congressional hearings, in state legislative proceedings, in courtrooms. Its findings were reported in scientific journals and mainstream newspapers. Its key figures Davenport, Laughlin were, within the world of American science and policy, significant and credentialed voices. The fact that what they were doing was not, in any rigorous scientific sense, science, that the methodology was flawed, the data collection invalid, the conclusions unjustified by any legitimate application of genetic theory was apparent to people who looked carefully. It was not apparent to the judges, the legislators, the editorial writers, the fairgoers who competed in the Fitter Families contests, or the Supreme Court justice who wrote those 3 pages. And it was not apparent, with consequences that would eventually require an international tribunal to fully address, to the government officials in Germany who were, in the early 1930s, watching American eugenics with intense and explicit admiration. But before we get to Germany, we need to understand the specific mechanism by which American eugenics achieved its most important legal victory and the specific story of the woman whose body was used to achieve it. We need to understand, in other words, the real story of Carrie Buck. In 1917, Albert Priddy, the superintendent of the Virginia State Colony for Epileptics and Feeble-Minded, was sued for sterilizing a woman named Willie Mallory without legal authorization. Priddy had, at that point, been performing involuntary sterilizations at the colony for several years, operating under the assumption that his authority over the institution's inmates extended to their reproductive capacity. He was wrong. Legally speaking, there was no statute in Virginia authorizing what he was doing, and the lawsuit made this clear. He won the case on the specific facts, but the experience taught him something important. The informal, extra-legal sterilization program he had been running could not continue indefinitely without a legal foundation. He needed a statute. He spent the next several years getting one. The law he eventually obtained, the Virginia Eugenical Sterilization Act, signed on March 20, 1924, was not improvised. It was carefully designed to address every constitutional objection that previous sterilization laws in other states had failed to survive. It was drafted by Aubrey Strode, a state legislator and lawyer who was also Priddy's personal legal counsel, which meant the man who wrote the law, that was about to be challenged in court, was also the lawyer who would be defending it. It was modeled closely on a model eugenical sterilization law that Harry Laughlin had published in 1922, a standardized template for sterilization legislation, designed specifically to survive judicial scrutiny. Distributed by the Eugenics Record Office to state legislatures across the country. And it was designed, from the beginning, to be tested in court, not because Priddy expected to lose, because he wanted the Supreme Court to say he could win. The test case required a subject. Priddy found one almost immediately. Carrie Buck arrived at the Virginia colony in June 1924. Shortly before her 18th birthday, the circumstances of her arrival tell you, with more clarity than any amount of institutional documentation, what the Virginia eugenics program was actually targeting. Carrie had been born in Charlottesville in 1906. Her father left when she was an infant. Her mother, Emma, struggled with poverty, and was eventually committed to the colony on grounds that included feeble-mindedness and sexual promiscuity, categories that in early 20th century institutional practice functioned primarily as labels for women who were poor, unmarried, and insufficiently deferential to the people classifying them. After Emma's institutionalization, Carrie was taken in by a family named Dobbs in Charlottesville. As a foster child, she was removed from school in the 6th grade and put to work as a domestic servant in the Dobbs household, cleaning, cooking, and performing the labor that the family required. This was not unusual for poor children in the foster care system of the era, but it is worth naming. Carrie Buck never had the educational opportunities that the people who later classified her as feeble-minded had assumed from birth. In 1923, Carrie was raped by Clarence Garland, a nephew of the Dobbs family who had come to visit. She became pregnant. The Dobbs family, faced with the social embarrassment of an unmarried pregnant girl in their care, had Carrie committed to the colony on the grounds of feeble-mindedness and moral delinquency. The rape was never mentioned in the subsequent legal proceedings. The pregnancy, the consequence of the rape, was cited as evidence of Carrie's hereditary tendency towards sexual immorality. Her daughter, Vivian, was born in March 1924 and remained with the Dobbs family. Carrie was sent to the colony, where Pretty, who had been looking for a suitable test case, identified her almost immediately as ideal for his purposes. Why ideal? Because Carrie's mother, Emma, was already in the colony, classified as feeble-minded, and because Carrie had just given birth, which Pretty interpreted as evidence of hereditary sexual immorality, and because Carrie was poor, uneducated, and without resources or family connections that might mount an effective legal defense. She was, from the perspective of the people constructing a test case, a perfect vehicle, 3 apparent generations of hereditary deficiency, available in one institutional setting, with no one capable of exposing the fraud at the heart of the case. The fraud was extensive. Pretty's assessment of Carrie's feeble-mindedness rested on testimony from witnesses, teachers, social workers, neighbors, most of whom had barely interacted with her, and none of whom applied any standardized clinical assessment. Harry Laughlin, who appeared as an expert witness, had never met Carrie Buck. He assessed her fitness for sterilization from a review of ERO field worker reports and his own theoretical framework. He classified her as an imbecile with a mental age of 9, a classification derived from an IQ test administered under conditions that no modern psychologist would recognize as valid by people who were looking for a specific result. The most consequential piece of the fraudulent case was the assessment of Vivian, the infant daughter whose supposed feeble-mindedness was needed to complete the 3 generations that made the case legally and rhetorically irresistible. Arthur Estabrook, a eugenics researcher from the ERO, visited the colony specifically to examine Carrie, Emma, and Vivian. He spent a single day there. He assessed Vivian when the child was approximately 7 months old. His assessment method consisted of looking at the infant and concluding that she had a look about it that is not quite normal. A social worker at the trial testified, similarly, that the baby had a look about it that struck her as wrong. This was the scientific evidence for the feeble-mindedness of the 3rd generation. A look. Vivian Buck, on the basis of an ERO researcher's visual impression of a 7-month-old infant, became one of the 3 imbeciles whose existence Justice Holmes would cite as sufficient justification for the permanent sterilization of her mother. Vivian died in 1932, at the age of 8, from an intestinal illness. She had, in the year before her death, been in the 1st grade at the school in Charlottesville. Her teacher, interviewed decades later by researcher Paul Lombardo, remembered her as bright and inquisitive. She had been on the school's honor roll the semester before she died. The third generation of imbeciles had made the honor roll. Now let's talk about Carrie Buck's lawyer. Irving P. Whitehead was experienced. He had been practicing law in Virginia for years. He was known in the legal community as a competent attorney. He was also, as legal historian Paul Lombardo's exhaustive research eventually established, a founding member of the colony's board of directors, a personal friend and political ally of both Albert Priddy and Aubrey Strode, and a committed supporter of eugenic sterilization. The man appointed to defend Carrie Buck against the state's effort to sterilize her without her consent was a man who believed the state should be able to sterilize her without her consent. At trial, in November 1994, Strode presented witnesses, teachers, social workers, neighbors, and 4 expert witnesses in medicine and eugenic science to establish Carrie's feeble-mindedness, her mother's feeble-mindedness, and the supposed deficiency of her infant daughter. His case was, by later assessment, not particularly strong. The evidence was largely anecdotal and institutional rather than scientific. The expert testimony rested on methodological assumptions that legitimate geneticists of the era had already begun to challenge. A competent defense counsel, prepared to call expert witnesses and challenge the scientific basis of the eugenics framework. You could have made this case considerably harder for Strode to win. Whitehead called no witnesses. He produced no evidence. He challenged none of the expert testimony. He did not contest the characterization of Carrie or her family as feeble-minded. He did not raise the fact that Carrie's pregnancy had been the result of rape, rather than the expression of hereditary sexual promiscuity. He did not contest the methodology of the intelligence assessments. He did not challenge Laughlin's deposition, which rested on a review of ERO records that Laughlin himself had helped to generate. Paul Lombardo, the legal historian, who has spent more time studying this case than anyone alive, put it plainly. A bystander might reasonably have reached the conclusion that there were 2 lawyers working for Dr. Priddy and none for Carrie Buck. After Whitehead's non-defense was complete, the circuit court found in favor of the colony. Priddy died of Hodgkin's disease in early 1925. Before the appeals could be completed, he was replaced as party defendant by his successor as colony superintendent, John Hendren Bell, which is why the case became Buck 5. Bell rather than Buck v. Priddy. The Virginia Supreme Court of Appeals upheld the lower court's ruling in November 1925. And Whitehead, the man who had mounted no defense at trial, then filed an appeal to the United States Supreme Court, claiming that Carrie Buck's 14th Amendment rights to due process and equal protection had been violated. This was, en face, the right argument. It was also, in context, the argument that the case's architects had been planning all along. The appeal to the Supreme Court was not a legal strategy to protect Carrie Buck. It was the next stage of a legal strategy to establish, at the highest level of the American judicial system, that the state had the right to sterilize people it deemed unfit. Whitehead's defense had been designed to lose at every level below the Supreme Court, building a clean, uncluttered record on which the Supreme Court could rule on the constitutional question, without being distracted by messy factual disputes about whether Carrie Buck was actually feeble-minded. Chief Justice William Howard Taft, former President of the United States, himself a eugenic supporter who had written warmly about eugenic principles earlier in his career, assigned the drafting of the opinion to Oliver Wendell Holmes Jr. Holmes had his own views on the subject. In 1921, in a private letter to future Supreme Court Justice Felix Frankfurter, Holmes had written that he had no difficulty with restricting propagation by the undesirables and putting to death infants that didn't pass the examination. He found eugenics congenial, not for reasons of racial animus. Holmes was not, in the typical sense, a race-obsessed ideologue, but for reasons that were, in their way, more intellectually considered, and therefore more durable. He was a thoroughgoing social Darwinist who believed that the improvement of the human species through selective pressure was as legitimate as the improvement of any other species, and that sentiment about the rights of the unfit was a self-indulgent impediment to social progress. He wrote the opinion in short order, 3 pages. 8 justices signed it. In those 3 pages, Holmes accepted as established fact the characterizations of Carrie Buck and her family that Whitehead had declined to challenge at trial. He did not question the methodology by which feeble-mindedness had been diagnosed. He did not examine the scientific basis for the heritability claims. He took the lower court's record at face value, the record that Whitehead had designed to be taken at face value, and proceeded directly to the constitutional question. His conclusion was that the state had the right to require this sacrifice. His comparison was to compulsory vaccination. His reasoning was that if society could demand the lives of its best citizens in wartime, it could demand the lesser sacrifice of sterilization from those who were, in his assessment, a burden on the state. And then the 3 sentences that everyone remembers: it is better for all the world if, instead of waiting to execute degenerate offspring for crime, or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. 3 generations of imbeciles are enough. The decision was handed down on May 2, 1927, on October 19, 1927. 5 months later, John Hendren Bell, the colony superintendent, performed a salpingectomy on Carrie Buck. He removed her fallopian tubes. She was released from the colony a month later. She subsequently married twice. She spent decades trying to understand why she could not have more children. She did not fully understand what had been done to her until Paul Lombardo, researching the case in the early 1980s, explained it to her. She died in January 1983, at the age of 76. She was buried in Charlottesville, a few steps from the grave of her daughter Vivian, the daughter who had been taken from her. Classified as feeble-minded on the basis of a researcher's visual impression of a 7-month-old infant, and who had died at 8 years old, having made the school honor roll. The aftermath of the decision was immediate and dramatic. In the decade following Buck v. Bell, 24 more states added or updated eugenic sterilization laws. The rate of sterilizations, which had been modest and inconsistent before the Supreme Court's blessing, accelerated sharply. In the 10 years after the decision, approximately 28,000 Americans were sterilized compared with 8,515 inches the entire period from 1907 to 1927. The Supreme Court had given the eugenics movement what it had been working towards since the Eugenics Record Office began compiling its millions of index cards: legal certainty at the highest possible level. Though what it wanted to do was constitutionally permissible. The specific populations targeted by the sterilization programs that followed tell you everything about what the science was actually measuring. They were poor, overwhelmingly poor. The sterilization programs ran through state institutions, asylums, reformatories, poorhouses, homes for the feeble-minded, and the people in those institutions were, by definition, the people who had ended up in state care, which in practice meant the people too poor, was too sick, too alone, or too different to navigate the world without institutional intervention. The category of feeble-mindedness was, in practice, applied with particular enthusiasm to women, poor women, unmarried women, Immigrant women. Women who had had children outside of marriage. Women who had been sexually assaulted. Women who had defied the social codes of their communities in ways that institutional authorities found troubling. In North Carolina, which had one of the most aggressive eugenic programs, running from 1929 to 1974, of the approximately 600 women sterilized, roughly 5,000 were black. The racial disparity in North Carolina's program was not exceptional. It was characteristic. The science of eugenics was not race-neutral in its application. Whatever its formal claims to biological objectivity, its practitioners brought to the work the racial and class assumptions of their era. And those assumptions shaped every stage of the process. Who got institutionalized? Who got assessed? How they were assessed? And who got sterilized? The Tuskegee-like dimension of this, the specifically racial targeting, the use of state power against communities with the least political resources to resist it, was not a perversion of the eugenics program. It was a natural consequence of a program that had always been beneath its scientific vocabulary, a technology for managing the unfit as defined by the people with the power to do the defining. California sterilized nearly 20,000 people. Virginia sterilized more than 8. Sambe. By the time the last active sterilization programs wound down in the 1970s, the Virginia law was not repealed until 1974. And some state laws remained technically on the books even longer. The total exceeded 60,000. Americans surgically deprived of reproductive capacity under laws whose constitutional legitimacy rested on Oliver Wendell Holmes's 3-page opinion about a woman who was not feeble-minded. Written in a case, her own lawyer had been working against her. There is a postscript to the Carrie Buck story that is worth telling in full, because it captures something about the specific human cost of institutional misinformation in a way that statistics cannot. In 1979, a researcher named Ray Nelson, who was investigating the history of eugenic sterilization in Virginia, located Doris Buck, Carrie's younger sister. Doris was living in poverty in rural Virginia. She had spent 50 years wondering why she could not have children. She had tried to conceive for decades. She had consulted doctors. She had grieved what she understood as infertility, without ever understanding its cause. She told Nelson that the institution had told her, when she was sterilized, that the operation was for appendicitis. She had believed this for 50 years. She had believed she had had her appendix removed and was unable to explain why she could not become pregnant. She was in her late 60s when she learned the truth. Her response, when she finally understood what had been done to her, is documented. She wept, and she said that she and her husband had always wanted children. This is the bottom of the eugenics story, not the Supreme Court opinions and the legislative acts and the ERO's millions of index cards, but Doris Buck in her 60s, learning that the infertility she had spent 50 years mourning was not a medical mystery but a deliberate act of state policy, carried out on her body while she was unconscious, justified by a science that had already been largely discredited by the time the operation was performed. The science of eugenics was never primarily about science. It was about power, about who got to decide whose children should be born, about which communities were assigned the label unfit and which were not, about which bodies the state had the right to permanently alter, and under what justifications. The justifications were scientific in their vocabulary and fraudulent in their application. The laboratory coats and the academic journals and the Carnegie Institution funding and the Cold Spring Harbor campus gave the operation its authority. The authority made the laws possible. The laws made Doris Buck's body available to a surgeon who was performing with the state of Virginia with the blessing of 8 Supreme Court justices, had determined was a public health procedure. She had wanted children. They decided she could not have them, and they called it science. Adolf Hitler had opinions about American eugenics. This is not a rhetorical flourish or a historically loose connection. Hitler had read about American eugenics programs in some detail, referenced them in Mein Kampf, and expressed what can only be described as professional admiration for what the Americans had built in his 1925 manifesto. Writing from prison in Landsberg, he described the United States as the one country that had made progress toward the racial hygienic ideals he was advocating, pointing specifically to American immigration restriction laws and the American sterilization programs as evidence that the principles of racial hygiene could be translated into effective government policy. He was not the only German reading American eugenics literature. The exchange ran in both directions throughout the 1920s. And it was a genuine intellectual exchange, not a polite acknowledgement of work in a distant country, but an active, ongoing correspondence between researchers, a mutual citation network, a shared project that was understood on both sides of the Atlantic as contributing to the same discipline. The Eugenics Record Office's newsletter, Eugenical News, served as one of the main conduits for this exchange. It reported on German developments in racial hygiene with approval, translated and published German texts, and served as a window through which American eugenicists followed the German movement's progress. Charles Davenport, the ERO's director, maintained personal correspondence with leading German eugenicists through the 1920s and into the 1930s. Harry Laughlin, in 1929, published a German-language article on the development of eugenic sterilization law in the United States, a practical how-to guide for German colleagues interested in the American model. The admiration was mutual. German eugenicists in the 1920s regarded the American movement with something close to envy. The United States had what Germany still lacked, a functioning legal infrastructure for eugenic sterilization, with Supreme Court blessing, backed by the resources of the Carnegie Institution and the Rockefeller Foundation. Operating at scale across dozens of states, the Americans had built what German racial hygienists wanted to build, and they had built it first. When Hitler came to power in January 1933, one of his government's first legislative acts was to translate that admiration into law. The Law for the Prevention of Hereditarily Diseased Offspring, Gesetz zur Verhütung erbkranken Nachwuchses, was signed by Hitler on July 14. Less than 6 months after he became Reich Chancellor. It provided for the compulsory sterilization of any German citizen who, in the opinion of a newly established genetic health court, suffered from any of 9 conditions presumed to be hereditary: feeble-mindedness, schizophrenia, manic depressive disorder, epilepsy, Huntington's chorea, blindness, deafness, severe alcoholism, or severe physical disability. The law was closely modeled on Harry Laughlin's model, eugenical sterilization law. Not loosely inspired by it, closely modeled. American eugenicists, reading the German law, in translation, said so themselves. The Eugenical News published a major assessment of the German law within 2 months of its enactment, praising the Nazi government as the first of the world's major nations to enact a modern sterilization law, and noting that the German law reads almost like Laughlin's American model statute. Paul Popenow, the director of the Human Betterment Foundation, a member of the board of the American Eugenics Society, and one of the American eugenics movement's most prominent public voices, published his own assessment of the German law in the Journal of Heredity in 1934. He praised it as well drawn and better than the sterilization laws of most American states. He praised the Nazi government for implementing it with the aid of Germany's leading eugenicists. He praised what he characterized as their conservative, sympathetic, and intelligent administration of the program. He praised Adolf Hitler, noting approvingly that Hitler had recognized the importance of negative measures being accompanied by the encouragement of sound parenthood. Paul Popenow, writing in an American scientific journal, in 1934, with the full weight of his institutional affiliations behind him, published what amounts to a favorable review of the Nazi eugenics program. This was not a fringe voice. Popenow was one of the most credentialed figures in American eugenics. His praise for the German sterilization law appeared not in a pamphlet or a political broadside, but in a peer-reviewed scientific journal. It represented the considered assessment of a significant faction within the American scientific establishment. In 1934, the California eugenicist C.M. Goethe returned from a visit to Germany where, by that point, more than 5,000 people per month were being forcibly sterilized under the new law, and wrote to a colleague with what can only be described as giddy enthusiasm. The letter is in the historical record, quoted in multiple scholarly sources, and it is worth reading in full because nothing summarizes the relationship between American and German eugenics more precisely than Goethe's own words. You will be interested to know that your work has played a powerful part in shaping the opinions of the group of intellectuals who are behind Hitler in this epoch-making program. Everywhere I sense that their opinions have been tremendously stimulated by American thought. I want you, my dear friend, to carry this thought with you for the rest of your life, that you have really jolted into action a great government of 60 million people. You have jolted into action a great government of 60 million people. Goethe was writing to a colleague at the Human Betterment Foundation, an organization dedicated to applying eugenic principles in California. He was expressing pride. He was sharing credit. He was telling an American eugenicist that the work they had done, the science they had produced, the laws they had lobbied for and celebrated, had been instrumental in producing what was now happening in Germany. He meant this as a compliment. Now let's talk about what was actually happening in Germany. The law for the prevention of hereditarily diseased offspring was implemented with the administrative efficiency that characterized the early Nazi state. Genetic health courts tribunals composed of a judge, a medical officer, and a medical practitioner were established across Germany to process sterilization cases. The courts operated with minimal procedural protection for the people appearing before them. Appeals were possible but rarely successful. In 1934, the first full year of the law's operation, approximately 600 cases were brought before the courts. Around 400 forced sterilizations were carried out. In a single year, nearly 4,000 people appealed their sterilization orders. More than 3,500 of those appeals failed. The law specified, with the bureaucratic precision of a government that had thought carefully about implementation, that the use of force is permissible when a subject refused to submit voluntarily to sterilization. This was not a theoretical provision. It was used within 12 years of the Nazi regime. Approximately 400,000 Germans were forcibly sterilized under this law. 400,000 people surgically deprived of reproductive capacity, in many cases without meaningful legal recourse, on the basis of diagnoses that range from the dubious to the fabricated, administered by courts whose decisions were driven by the ideological priorities of a totalitarian state. The same American eugenicists who had praised the law in 1933 and 1934 continued, in some cases, to praise it as late as 1940. Harry Laughlin and Lothrop Stoddard, both prominent figures in the American eugenics establishment, were still expressing approval of the German sterilization courts in 940, 7 years into the operation of a program that had by then forcibly sterilized hundreds of thousands of people. It is worth pausing on this timeline. These were not people who were praising a policy before its consequences became clear. 1940, the German sterilization program had been operating for 7 years. Its scale, its methods, and its consequences were documented in international press coverage that any engaged observer could access. American eugenicists who praised it in 1940 were praising a program whose human cost they had had ample opportunity to assess. They praised it anyway. In June 1936, Heidelberg University celebrated its 550th anniversary. The celebration included an academic ceremony at which honorary doctorates were awarded to distinguished scholars from around the world. Heidelberg specifically invited Harry Laughlin to receive an honorary degree in recognition of his contributions to the science of eugenics. The date of the ceremony was not incidental. Heidelberg had scheduled it on the anniversary of Hitler's 1934 purge of Jewish faculty from the university, an event that had expelled dozens of scholars from one of Germany's oldest academic institutions. The honorary doctorate was being awarded at a ceremony whose symbolic context was the Nazi transformation of German academic life. Laughlin could not attend in person. He lacked the funds for the transatlantic journey and had to collect his degree from the Rockefeller Institute in New York, where a representative of Heidelberg University presented it to him. He wrote afterward that he considered the honor not merely as personal recognition but as evidence of the common understanding of German and American scientists of the nature of eugenics as the science of the biological improvement of man. Common understanding of German and American scientists. The man who had written the model sterilization law that served as the template for Nazi legislation, who had testified, without meeting her, that Carrie Buck was the shiftless, ignorant, and worthless class of antisocial whites of the South, was receiving an honorary degree from a German university whose Nazi administrators were overseeing the forced sterilization of 400,000 of their citizens. And he framed it as a collegial professional honor, a recognition of shared scientific values. This is the specific horror of institutional science, weaponized in service of mass atrocity. Not that it was performed by people who understood themselves as monsters, but that it was performed by people who understood themselves as scientists. Laughlin accepted his Heidelberg degree as a scientist, receives recognition for a contribution to knowledge. Goethe wrote his letter about jolting the German government into action as a scientist proud of his field's influence. Popenow published his favorable review of the Nazi sterilization law as a scientist assessing a policy's scientific merit. They had convinced themselves, or had always believed, which is arguably worse, that what they were doing was science. That the ERO's millions of index cards, the Fitter Families contests, the model sterilization law, the testimony at Buck v. Bell, the correspondence with German colleagues, all of this was the application of rigorous biological principles to the improvement of humanity. The human beings whose reproductive capacity they were campaigning to eliminate were not, in this framework, the subjects of a moral decision. They were variables in a scientific problem. This is, in the end, what made the American eugenics movement's contribution to the Holocaust not incidental but structural. It was not merely that American eugenics provided legal precedents that Nazi lawyers could cite in their defense, though it did that. It was not merely that Lauchlin's model law provided a template for the Nazi sterilization statute, though it did that too. It was that American eugenics provided the intellectual and institutional vocabulary through which a government could describe the elimination of human beings' reproductive capacity as a scientific rather than a political act. It provided the framework within which forced sterilization could be presented to a domestic and international audience as a public health measure, rather than an atrocity. Without that vocabulary, without the journals and the institutions and the Carnegie Institution funding and the Cold Spring Harbor campus and the honorary degrees and the favorable reviews in peer-reviewed journals, the German racial hygiene program would still have been morally catastrophic. But it would have been less defensible. It would have been harder to present as the natural extension of a legitimate scientific tradition. It would have been harder at Nuremberg for Nazi defense lawyers to point to the United States Supreme Court and ask, if what we did was a crime, what does that make this? The specific legal use of Buck v. Bell at Nuremberg is documented in the trial records. Karl Brandt, Hitler's personal physician, a driving force behind the Action T4 program that murdered more than 250,000 disabled people, and the senior defendant in the Nuremberg doctors' trial, was charged with, among many other crimes, overseeing the forced sterilization of concentration camp inmates. His defense team, seeking to challenge the prosecution's characterization of the Nazi sterilization program as a crime against humanity, introduced documentary evidence of sterilization programs in other countries. The United States was prominent among the countries cited. The Buck v. Bell decision was quoted in translation from a German text on eugenics as evidence that compulsory sterilization had the endorsement of America's highest court. The exhibit introduced by Brandt's lawyers was titled Race Protection Laws of Other Countries. It included not only Buck but also a citation of Harry Laughlin's 1914 proposal, calling for the sterilization of 15 million Americans, a figure that, by the standards of the American Eugenics Society's stated goals, was actually considered modest. SS officer Otto Hoffmann, another Nuremberg defendant heavily involved in the final solution, introduced a 1937 brief on sterilization laws in different countries that also cited Buck and the Holmes opinion. Their argument was straightforward. How can you prosecute us for doing what your own Supreme Court has blessed? They had a point. Not a morally exculpatory point. The scale, the racial targeting, and the context of Nazi sterilization policy were categorically different from even the worst of the American programs. And the subsequent progression from sterilization to extermination was a specifically Nazi development, for which no American precedent provided cover. But as an argument about intellectual consistency, it was not without force. The men who had designed the German program had read the American program, praised it, corresponded with its architects, modeled their law on its model law, and received honorary degrees from German universities in recognition of the shared project. The American eugenicists who had provided this intellectual infrastructure were still alive, still publishing, still receiving professional recognition, still in some cases praising what the Germans had done. Karl Brandt was found guilty and executed in 1948. His defense did not save him, but the specific evidence he introduced, the Buck v. Bell decision, cited in a German courtroom as precedent for the Nazi sterilization program, stands as perhaps the most precise documentation of the relationship between American scientific respectability and Nazi mass atrocity. The scientific community that had built the ERO, funded it through Carnegie and Rockefeller, celebrated its ad fita families contests, gave it journal space, lent it the authority of academic prestige. This community did not, for the most part, acknowledge its role in what the Germans had done. Some members of the mainstream genetics establishment had been critical of eugenics since the early 1930s, and became more vocally so after the full scale of the Nazi program became apparent. The Carnegie Institution closed the Eugenics Record Office in 1939, not with any public apology or acknowledgement of harm, but quietly, as an embarrassment that had become too visible to maintain. The American Eugenics Society did not dissolve itself. It continued to operate, rebranding its work in subsequent decades under different terminology. Laughlin was pushed out of the ERO in 1939, partly due to health problems, and partly due to his increasingly obvious association with Nazi ideology, and died in 1943 still, by all accounts, believing that his model sterilization law had been one of his great contributions to science. The states that had enacted sterilization laws on the basis of the science he had helped build continued to operate those programs. In many cases, for decades after the war, Virginia's law was not repealed until 1974. California's forced sterilization program continued into the early 1950s, with a specific targeting shifting increasingly toward Mexican and Mexican-American women. In the years between 1997 and 2010, according to documented records, approximately 400 women in California prisons were subjected to coerced sterilizations. Not 1,940, not 1,960. Between 1997 and 2010, the idea that the American eugenics program ended with the war, or with the closing of the ERO, or with the Nuremberg trials, this idea is false. The specific institutional infrastructure of the ERO era was dismantled. The specific language of feeble-mindedness and germplasm and racial hygiene became professionally toxic. But the underlying practice, the use of state authority to permanently eliminate the reproductive capacity of poor women, women of color, disabled women, and women whose lives the state had judged inconvenient, this practice continued, under different names, with different administrative justifications, for decades after anyone would admit to believing in eugenics. The science changed its name. The power it had authorized did not change its behavior. There is one more figure in this story who requires mention before we turn to the aftermath. His name was Josef Mengele. He is relevant here not primarily for the atrocities he committed at Auschwitz, which are documented extensively elsewhere, but for the specific institutional lineage that connected his work to the American funding apparatus that had supported German eugenics before the war. The Kaiser Wilhelm Institute for Anthropology, Human Heredity, and eugenics, established in Berlin in 1927, with significant financial support from the Rockefeller Foundation, was one of the leading centers of German racial science in the years before and during the Nazi period. Its founding director was Eugen Fischer, a eugenicist whose work had been sent to American colleagues by Charles Davenport in the 1920s as part of the transatlantic exchange. The institute received Rockefeller Foundation funding into the early 1930s, funding that continued for a period after Hitler came to power, while the Rockefeller Foundation navigated the question of whether to maintain its scientific relationships in Germany. Josef Mengele, the Auschwitz physician whose twin studies and other experiments became one of the defining symbols of Nazi medical atrocity, received his training partly through the Institute's research program, the institutional chain from the Rockefeller Foundation's support for German eugenics research, through the Kaiser Wilhelm Institute, to Mengele's fellowship at the Institute before the war, is documented and has been analyzed extensively by historians, including Edwin Black. This does not make the Rockefeller Foundation responsible for Mengele's crimes at Auschwitz. The chain of causation is not that direct, but it does establish, with documentary precision, the degree to which the financial and institutional infrastructure of American philanthropy was intertwined with the German scientific establishment that produced the intellectual and professional environment in which a man like Mengele was trained and credentialed before the war. The American eugenics movement did not build the Holocaust. It did not intend the Holocaust. Most of its architects, if they had been told in 1927 where the path they were laying would lead, would have won hopes, though history does not always support such optimism, recoiled. But they built the vocabulary. They built the institutional templates. They provided the legal precedents. They maintained the scientific correspondence. They received the honorary degrees. They praised the German law. They called it science. And when the science was used in a courtroom in Nuremberg to defend crimes against humanity, and the defense lawyers who used it were not distorting it. They were citing it accurately. They were citing the actual precedent, established by the actual Supreme Court, written by the actual preeminent legal mind of his generation, in a case that had been staged from the beginning to produce exactly the result it produced, the permanent, irreversible, surgical elimination of a woman's ability to have children on the basis of a fraud in the name of science. Carrie Buck was 21 years old when it happened. Oliver Wendell Holmes said 3 generations of imbeciles were enough. None of the 3 generations were imbeciles. The science said so. That is the point. In 1946, the United States of America put 23 German doctors and scientists on trial for crimes against humanity. The charges included the murder of concentration camp inmates in the course of medical experiments, the use of prisoners as non-consenting subjects in research on hypothermia, high altitude, infectious disease, and surgical procedures conducted without anesthesia, and the forcible sterilization of people deemed racially or genetically unfit by the Nazi state. It was, by any measure, a prosecution of genuine atrocities. The things these men had done in the name of science, with the endorsement of the German state, with the institutional support of German medical universities and research organizations, were horrific. The prosecution was right to prosecute them. The sentences, some of which were death, were, given the evidence, difficult to dispute on purely logical grounds. The defense, however, raised an argument that the American prosecutors had not fully anticipated, and that the American legal establishment had no entirely comfortable answer to. The argument was this: the United States, whose military tribunal was sitting in judgment over the German sterilization program, had its own sterilization program, its own Supreme Court, the highest court in the country. The institution whose moral authority underpinned the entire American legal tradition that was being invoked at Nuremberg had specifically, explicitly, and with the apparent blessing of the legal community's most distinguished mind, declared forced sterilization to be constitutionally permissible. More than 60,000 Americans had been sterilized under that ruling. The model law that served as the template for the German sterilization statute had been written by an American, celebrated by American academic institutions, and used by more than 30 American states. Karl Brandt's defense team introduced the Buck IV Bell decision as a defense exhibit. The document, labeled Race Protection Laws of Other Countries, cited Holmes's opinion. Other defendants cited it too. Harry Laughlin's 1914 proposal for the sterilization of 15 million Americans appeared in the evidence introduced on behalf of Hitler's personal physician. The Nazi defendants who cited Buck v. Bell were not, in this specific instance. I'm wrong about the facts. The precedent was real. The law was real. The sterilizations were real. The Supreme Court opinion was real. The American eugenics movement had done what they said it had done. And the German eugenics program had done what they said it had drawn from it. The American prosecutors, to their credit, did not try to pretend this was untrue. They argued, correctly, that the scale and racial targeting of the Nazi program exceeded anything in the American context, and that the Nazi sterilization program was embedded in a broader program of racial extermination that had no American parallel. These arguments were legally sound. They were also, as arguments about moral consistency, less than entirely satisfying. Brandt was convicted. He was executed in June 1948. The argument he made did not save him, but it did not go away either. It remained in the trial record. A specific documented instance in which the authority of American science and American law had been cited accurately in defense of crimes against humanity. No American political figure was asked to account for this. No congressional hearing examined what the American eugenics movement's contribution to Nazi science had been. The ERO was already closed. Laughlin was dead. The Carnegie Institution had quietly distanced itself. The mainstream genetics establishment had, by the late 1930s, moved to dissociate itself from the most egregious claims of the eugenics movement. And the war had given everyone the cover of a clean break. Eugenics was what the Nazis did, not what we did, not what the Carnegie Institution funded, or what the Supreme Court blessed, or what Oliver Wendell Holmes wrote in 3 pages that remain. Technically, on the books, the clean break was a fiction, and the fiction was expensive, because the sterilization programs did not end with the war. Let's be precise about this. Because it is one of the most important facts in the history of American eugenics, and one of the least well-known. The United States performed eugenic sterilizations for decades after Nuremberg, not as a relic nobody noticed, as ongoing, active, documented policy. Virginia's sterilization law remained on the books until 1974, 28 years after the Nuremberg trials concluded. The last involuntary sterilization at the Virginia colony is documented as occurring in 1956, though the practice may have continued informally after that. North Carolina's Eugenics Board, the state body responsible for approving sterilization petitions, did not close until 1977, 50 years after Buck v. Blanks. Bell. The state's sterilization laws were not formally repealed until 2003. Its eugenics program targeted, with increasing specificity as the decades went on, poor black women. Deborah Blackman was sterilized in 1972 by court order, citing state law, by a judge operating within the legal infrastructure that Buck v. and Bell had sanctified at the age of 14. She was told nothing about what had happened to her. Her father, sitting in the waiting room of the hospital as she gave birth to her child, was told only that she was having a minor procedure. He wept. He asked them not to hurt her. They did not explain what they were doing. 1972, 25 years after the Nuremberg verdict. California, the state whose sterilization program had most directly inspired the Nazis, whose eugenics leaders had returned from Germany in 1934 full of pride about having jolted into action. A great government of 60 million people did not repeal its sterilization law until 1979. And then, in the following decade, with the eugenics law gone and the institutional framework officially dismantled, the practice quietly continued in a new institutional setting. The state prison system, between 2006 and 2010. Doctors under contract with the California Department of Corrections and Rehabilitation performed approximately 150 tubal ligations on incarcerated women without required state approvals. The women were sterilized during childbirth, in many cases, without their informed consent. Some were pressured, harassed, and in some cases deceived about what was being done to their bodies. 2/3 of the women subjected to these procedures were women of color. The OB/GYN at Valley State Prison for Women, when asked about the procedures, offered an explanation whose language connects the 2006 to 2010 program to the 1927 Buck v. Bell era with the seamlessness of an unbroken tradition. He said, according to the Center for Investigative Reporting's investigation, that the cost of performing the sterilizations was not a huge amount of money compared to what you save in welfare paying for these unwanted children as they procreated more. Cost-benefit analysis. Sterilizing poor women to save welfare expenditures on their children. In 2006, In California, in a sentence whose structure and logic and specific invocation of the costs of the unfit reproducing is indistinguishable from the arguments made by Albert Priddy at the trial of Carrie Buck in 1924, California banned the practice by law. Senate Bill 1135, signed by Governor Jerry Brown in September 2014. Not 1,950, not 1,974, 2014. The bill passed both chambers of the California legislature unanimously, which is worth noting. It required unanimous consent to prohibit, in 2014, the coerced sterilization of incarcerated women. This means that before 2014, there was no law specifically prohibiting it. In 2021, California set aside $4.5 million to compensate women who could prove they had been involuntarily sterilized in state prisons, paying approximately $35,000 per eligible victim. Applications opened in 2022 and closed at the end of 2023. There is no way to square these dates with a narrative in which American eugenics ended at Nuremberg, or with Buck v. Bell's subsequent narrowing, or with the closing of the ERO in 1939. The practice did not end. It changed its vocabulary, its institutional setting, and its targets, but poor women of color continued to have their reproductive capacity eliminated by state action, under state authority, with medical professionals performing the procedures. For decades after the science that had originally justified the practice was universally recognized as fraudulent. This is the specific failure of the reckoning that followed Nuremberg. Not that there was no reckoning with Nazi atrocity, there was, and it was genuine. And the Nuremberg trials established principles of medical ethics that remained foundational to the field. But the reckoning was asymmetric. It held Germany to account for what Germany had done. It did not hold the United States to account for what the United States had provided: the intellectual infrastructure, the legal precedent, the scientific vocabulary, or for what it continued doing, in quieter ways. For decades afterward, the Nuremberg Code, the 10 principles of medical ethics formulated in the aftermath of the doctor's trial, establishing that informed consent is an absolute prerequisite for any medical procedure on a human subject, was, specifically, a response to Nazi medicine. It became foundational to international medical ethics, and it was applied, inconsistently, in the United States. The Tuskegee syphilis study, which continued to deny treatment to black men with syphilis until 1972, 3 years after the moon landing, and 25 years after Nuremberg was ended, not by the application of the Nuremberg Code, but by a whistleblower and a press leak. The prison sterilizations in California continued until 2010. Decades after the Nuremberg Code had been incorporated into every medical ethics curriculum in the country. In 2002, North Carolina Governor Mike Easley formally apologized for the state's eugenics program. It was the first such apology by any American state. The apology was not accompanied by compensation that came a decade later, through the efforts of legislators and journalists who spent years fighting for recognition. In 2013, after a campaign that had begun in earnest with investigative reporting by the Winston-Salem Journal in 2002, and continued through a decade of task forces and legislative battles and appropriations fights, North Carolina became the first American state to compensate victims of its eugenics sterilization program. The compensation fund was $10 million. The payment per eligible victim was $50,000. Though most victims ultimately received approximately $20,000. Due to the number of approved claims relative to the fund. 7,600 people were sterilized by the North Carolina Eugenics Board, between 1,929 and 974. Of those, approximately 200 came forward and were verified as eligible for compensation. The rest either had not survived, were not aware of their eligibility, could not produce the required documentary evidence because the state had not preserved full records, and some sterilizations had been performed at the county level without eugenics board documentation or had died before the June 30, 2013 deadline, after which survivors were not eligible. One woman who had not survived to receive compensation was Elaine Riddick. Riddick had been sterilized at the age of 14 in 1968. While giving birth to a son who was the product of a rape, the North Carolina Eugenics Board had classified her as promiscuous and unable to get along with others and determined she was unfit to reproduce. She had spent years telling her story publicly, demanding recognition, demanding accountability. She described what had been done to her in words that are among the most precise formulations of what the eugenics movement actually was. Beneath its scientific vocabulary, I was raped twice, once by the perpetrator and once by the state of North Carolina. The second rape was scientific. It was bureaucratic. It had a case file. It had a board vote. It had a signed form signed, in this case, by her grandmother, who could not read and may not have understood what she was authorizing. It had a surgeon, and a hospital, and the full institutional weight of a state government that had decided, with the authority that Oliver Wendell Holmes had lent it in 1927, that Elaine Riddick was not fit to have more children. The state of North Carolina eventually acknowledged this. It apologized. It created a compensation fund. These are real things, and they matter. The acknowledgement of a wrong is not nothing, even when it comes late, even when the compensation is inadequate, even when hundreds of victims have died waiting for it. But here is what the acknowledgement did not do. It did not ask how a state had managed to perform 600 coerced sterilizations over 4 decades with the active involvement of social workers, doctors, judges, welfare officers, and medical institutions, without any of those individuals being named or held individually accountable. The North Carolina apology was an apology by an institution to the people that institution had harmed. It was not a reckoning with the individual decisions made by the individual people who had operated the apparatus, the doctors who performed the surgeries, the social workers who filed the petitions, the board members who voted, the judges who signed the orders. These people are not, for the most part, in the historical record as perpetrators. They are in the historical record as administrators, as professionals doing their jobs, as people operating within a system that was, in their era and their institutional context, legitimate. This is the hardest lesson of the American eugenics movement, and it is the lesson that connects it most directly to the larger theme of this season, that institutional science with the right vocabulary, the right funding, the right academic affiliations, the right Supreme Court precedent can authorize things that common decency would otherwise prevent. That the authority of science is not a guarantee of the morality of what is done in its name. That the data indicates and the research supports and the board is determined are not moral conclusions. They are processes, and processes can be corrupted by the assumptions of the people running them, by the political pressures on the institutions funding them, by the social anxieties that the vocabulary of science gives a respectable language to express. The eugenics movement did not succeed because it was populated by sadists. It succeeded because it was populated by people who believed they were doing something good, something progressive, something scientific, something that would benefit humanity. The Fitter Families contests were cheerful. The ERO's field workers were mostly young women with biology degrees who believed they were contributing to human knowledge. The Supreme Court justices who signed Buck v. Bell were not monsters. They were, most of them, distinguished men who had spent careers thinking carefully about the law and who found the eugenics argument, in its scientific presentation, persuasive. And this is precisely what makes it dangerous. The history of eugenics is not a cautionary tale about what happens when bad people use science. It is a cautionary tale about what happens when good people, careful people, credentialed people, well-intentioned people use bad science without subjecting it to the moral scrutiny that any program with this kind of power over human lives demands. The specific scientific errors of eugenics, the misapplication of Mendelian genetics to complex traits, the confusion of social categories with biological ones, the failure to account for environmental factors, the methodological invalidity of the pedigree studies. These were known and stated and published in legitimate journals by legitimate scientists throughout the period when the movement was operating. Thomas Hunt Morgan said so in 1925. Herbert Spencer Jennings said so throughout the 1910s and 1920s. The criticisms were available. They did not prevail, not because they were wrong, but because they were competing against a framework that served too many powerful interests and answered too many anxious questions to be abandoned on the basis of methodological objection. This is how institutional misinformation works, when science is the institution. It is not a lie. Exactly. The eugenics researchers genuinely believed they were doing science. The journals that published them genuinely believed they were advancing knowledge. The Supreme Court that blessed the program genuinely believed it was making a reasoned legal judgment. The fraud was not in anyone's specific intention. It was in the collective failure of the scientific community, of the legal system, of the political establishment, of the press, that reported favorably on the Fitter Families contests to maintain the critical distance from a powerful and popular idea that serious science demands. There is a specific, terrible irony embedded in the history of American eugenics that deserves to be named directly. The people who were targeted by the eugenics programs, the poor, the disabled, the immigrant, the black, the institutionalized, the women who had been raped and then classified as sexually promiscuous. These were exactly the people who had the least power to resist the institutional apparatus that was being directed at them. They could not commission research to challenge the ERO's methodology. They could not afford lawyers who would mount the defense that Carrie Buck's appointed lawyer declined to mount. They could not publish in the journals. They could not speak at the conferences. They could not vote for the legislators who passed the laws or appoint the judges who blessed them. The science that classified them as unfit was produced by people with access to all of these resources. The gap between who produced the science and who was subjected to it was not incidental to what happened. It was the mechanism. This is why the eugenics story matters beyond its specific historical context. It is not primarily a story about genetics, or about the 1920s, or about Oliver Wendell Holmes. It is a story about what happens when the authority of science is available to powerful people, and the subjects of that science have no voice in its production. It is a story about what peer review means when the peers are all from the same institutions, share the same assumptions, and serve the same interests. It is a story about the difference between scientific authority and scientific truth, and about how catastrophically expensive it can be when that difference is not maintained. The Nuremberg Code tried to address this difference by establishing that the consent of the subject is the non-negotiable foundation of ethical medical research. You cannot do science on a person without their informed agreement. This principle, simple, clear, apparently obvious, was articulated in 1947 precisely because the events that made it necessary demonstrated that it was not, in fact, automatically observed by scientists operating within institutional frameworks that gave them access to captive populations. The code came too late for the 60,000 Americans who had already been sterilized. It came too late for the 400,000 Germans. It came, in the California prison system, too late for the 150 women sterilized between 2006 and 2010. But it came, and it named, with precision, the thing that the eugenics movement had failed to do. It required that the person on whom the science was performed be treated as a person, as an agent, with rights. Notas de variable non equation. The ERO's index cards did not have that requirement. They had categories. They had pedigree lines. They had trait assessments made by field workers who spent a day in an institution and rendered judgment on generations. They had, in extraordinary abundance, the paperwork of scientific respectability, and they produced, in extraordinary abundance, the authorization of harm. Carrie Buck lived until 1983. She was 76 years old. She had spent her adult life working as a domestic worker, the same work she had been doing in the Dobbs household when she was raped and committed and sterilized and released. She had married twice. She had loved her husband. She had, with characteristic grace and the absence of bitterness that makes her story even more wrenching, spent her later years in a nursing home in Waynesboro, Virginia, where Paul Lombardo visited her in the months before her death. Lombardo asked her about her daughter, Vivienne, the child who had been taken from her, the infant whose look had been assessed by a eugenics researcher in a single visit as not quite normal. The third generation of imbeciles who had made the school honor roll and died at 8 years old. Carrie Buck wept. She told Lombardo she had never stopped thinking about Vivienne. She told him she had always wanted to know more about her, about what kind of child she had been, what she had been like, what her life had been. She had been allowed almost no information. The Dobbs family, who had raised Vivienne after her removal from Carrie, reported on Vivienne's death certificate that they did not know the name of her birth mother. The system had been thorough. It had taken her daughter. It had taken her reproductive capacity. It had, in the official record, taken the fact of their relationship. The death certificate said the mother was unknown. The mother was not unknown. The mother was Carrie Buck. She was alive. She was a few miles away. She was thinking about her daughter. The science said she was an imbecile. The science said her daughter was an imbecile. The science said 3 generations were enough. The science was wrong about all of it. And the people who said so, the geneticists who challenged the ERO's methodology, the dissenting justice who said nothing but voted no, the women who spent decades trying to explain what had been done to them, these people are the other side of the eugenics story. The side that is less well remembered. The side that proves the science was always contestable. The consensus was always narrower than its proponents claimed. The certainty was always less than the authority behind it suggested. The certainty was institutional. The truth was elsewhere. It was in the first-grade classroom where Vivienne Buck was remembered as bright and inquisitive. It was in the school honor roll. It was in Carrie Buck's memory of a daughter she had been allowed almost no time with. It was in Doris Buck's 50 years of inexplicable infertility. It was in Elaine Riddick saying, with devastating precision, that she had been raped twice. It was in all the places the index cards did not reach.